I decided to call this video the Civil Lawsuit Steps. And I thought that this would be important because it's something that I'm going to refer my clients to. Go home and watch this video and you'll understand it, okay? This is the steps of a civil lawsuit. Now, this is very simple. This varies, okay? But this will give you a concept. If I'm representing you, you'll know kind of what to expect. First of all, we meet with you, we prepare the facts, we research the law, we make that monumental decision to file that lawsuit. That lawsuit then has to be served upon the persons that you sued. If it's a business, they have what's called an agent of service of process. If it's an individual, it has to be served on them. After they are served with the lawsuit, that means it's mailed to them by certified mail or the sheriff delivers it to them. Once they get that lawsuit, in Kentucky you have 20 days to file an answer. In Ohio you have 28 days to file an answer. If it's a federal lawsuit like an employment case or a jail and police misconduct case, if it's a federal lawsuit, there's something where they signed a waiver and then they accept service and then they have 60 days to answer. It's a longer process out the gate in a federal lawsuit. In a claim in Ohio, what they do in Ohio is they usually do a scheduling order. Once that lawsuit's filed, you have an initial case conference, and they will set all the dates all the way up into the trial. And we mail our clients a copy of that order, then you'll know. In Kentucky, after you file the lawsuit and they file what's called the answer to the lawsuit in a Kentucky claim, what happened, and this goes in Ohio too, you exchange what's called discovery. They're called interrogatories and requests for production of documents and requests for admissions. They send them to us. You have 30 days to answer them. We send a set to the other side. They have 30 days to answer. This gives preliminary information to both parties. Where did you live? Where did you work? What's your medical condition? What happened? Those type of questions. In a federal case, there's a status conference where the parties meet, line out a schedule, and then they exchange some documents voluntarily. After that process is over in both a federal or a state claim, you take what's called depositions. The first person that has to be deposed is always the plaintiff. That's the way it works. The plaintiff's deposed, then the defendant's deposed, then other witnesses are deposed. And a deposition is simply that. You sit in a room, the lawyer asks you questions, and a court reporter takes down everything that is said and recorded, and you're under oath. After the deposition process is over, that's when you usually get a trial date and you're off to trial. At any time from the date that the time you come to see me, all the way up through the trial, at any time, that case can be settled. Sometimes it could be settled and worked out. Sometimes the case is dismissed. Sometimes the facts fall apart for one or both parties. Sometimes we think we have a good case and it falls apart. Sometimes we think our case is a little weak and it gets better. We find a smoking gun, so to speak. Courts generally, both federal and state courts, Kentucky and Ohio, refer most matters to mediation at some point in time. And you're going to learn what a mediation is. It's just an informal process where we go with you to a meeting with the other sides there, with the insurance carrier and a lawyer or a judge who serves as a mediator, and you spend all day trying to settle the case. Also, if you have a trial, there's an appellate process that goes on. But this is just a little brief overview for you of the civil process. What I tell my clients to do, if you don't hear from me otherwise, call me every 30 days. Now, if you have something that's really important to tell me, you don't have to wait 30 days. But I like my clients touching base with me every 30 days because the law moves in 30-day intervals. You file a lawsuit, they have 20 to 28 days to answer. Then you have discovery, which takes 30 days, and then you set up depositions. I mean, things kind of move, and that's as fast as it can go. So I tell my clients to call me every 30 days. But I hope this gives you a little idea of the process in a civil lawsuit.